Ottawa, the national inquiry into the invocation of the Emergencies Act. In the wake of the truckers' convoy occupation of downtown Ottawa, is going to be used as a political bullhorn for all kinds of individuals and groups who have been granted standing. Commissioner Paul Rouleau will need to keep a tight grip on proceedings to prevent them pinballing all over the place, as discredited police officers and politicians seek to rehabilitate their reputations, and disgruntled provincial governments express umbrage that they were not consulted. But Lakehead University law professor Ryan Alford made an opening statement that gets to the nub of the inquiry. The federal government has to prove it met the legal standard for using the emergency provision of last resort. Alford said that in its opening statement the Government of Canada's counsel, Robert McKinnon, had said Ottawa had a reasonable basis for declaring a public order emergency. Unfortunately, a reasonable basis is not a legal, let alone constitutional, basis for using unprecedented and destructive emergency powers, he said. In its order in council, the government said the blockades in Ottawa were being carried out in conjunction with activities that are directed toward or in support of the threat or use acts of serious violence. But, as Alford pointed out, the correct legal standard for threats to the security of Canada requires those acts to be direct, not tied to serious acts of violence in some fashion, not in conjunction with or association in some fashion. The onus is on the government to prove that it believed there was a clear and present threat to national security from the truckers' convoy that existing legislation could not contain. The rule of law requires nothing less, said Alford. McKinnon made the case that the imposition of the Emergencies Act was indeed a measure of last resort and was proportional to the threat. But Brendan Miller, counsel for the Freedom Group of protesters, said that there was no justification for the government exceeding its constitutional bounds. He said the inquiry is not going to hear that protesters were engaged in sabotage or clandestine acts, that they were being manipulated by foreign influence, that they used serious violence against people or property, or that they were intent on destroying or overthrowing the government of Canada. To be clear, the illegal occupation in Ottawa was best summed up in the emergency debate in the House of Commons at the time by Conservative MP Michael Chong, who said all Canadians have the right to protest, as a fundamental freedom enshrined in the Constitution. But they do not have the right to blockade streets, highways, border crossings, rail lines or pipelines. There is no right to harm other people or interfere with the freedom of fellow citizens, he said. Article content. The rally organizers claimed they were champions of freedom, but their protest meant the gates of Parliament were bolted, literally. Yet, the police had already cleared protests in Coutts, Alta, and Windsor, Ontario, without resorting to the Emergencies Act's provisions. Many of those arrested in Ottawa were charged with committing mischief, an offence already on the books. Trudeau said the Emergencies Act provisions were needed to compel tow truck drivers to remove the big rigs from downtown. But as Senators Claude Carignan and Jean-Guy Dagenais have pointed out, the Ontario Highway Traffic Act already gave police powers to force towing companies to act to ensure the orderly movement of traffic. The invocation did allow the government to take measures that still seem inconceivable in a modern democracy, such as freezing or suspending the bank accounts of anyone involved in the blockade, without a court order. Article content. The explanation given by Public Safety Minister Marco Mendicino was that the protests were coordinated by a small, organized group driven by an ideology to overthrow the government through whatever means. Canadians have been forced to take that statement on faith, until now. The Commission's first day allowed counsel for all parties with standing to summarize their case. We will subsequently have 30 days of hearings before the final report is delivered by Judge Rouleau to Parliament on February 20th. As he pointed out, the timeline is tight, in comparison to other federal commissions of inquiry that have lasted years. The judge will be granted access to cabinet confidences, only the fourth time in Canadian history. That cabinet privilege has been waived. He will also have access to sensitive information deemed to have national security implications, which will not be made public. If the cabinet did receive intelligence that there was an organized group of ideologically driven insurrectionists involved in the truckers' convoy, the commissioner will find out, and we must trust that he lives up to his commitment of openness and transparency to hold the government to account. The suspicion is that the Americans were getting antsy about the impact on international trade and the Liberal government panicked. Certainly, the order in council used to implement and justify the legislation talks more about the relationship with trading partners, the adverse effect on the Canadian economy and the breakdown in distribution chains than it does about the security of Canada. Concerns about the economy are serious, but they don't justify the circumvention of Parliament or the executive arm of government ruling by fiat. When Tommy Douglas, the founder of the NDP, opposed Pierre Trudeau's War Measures Act, he called its use a sledgehammer to crack a peanut. It is up to Justin Trudeau and his ministers to make the case in front of the Commission that the nut they had to crack was much tougher than a rowdy occupation by a bunch of unsophisticated troublemakers.